Hello to everyone, and thank you for joining another webinar hosted by Russian Arbitration Association 25. Today we will continue talking about arbitration in different jurisdictions, and this webinar is a bit special as we'll be hosting it in English completely. And our guest today will present the basics but also current trends of arbitration in India. We'll also discuss whether India has a potential for being the seat of arbitrations for Russian parties. The reason why we decided to pick India as our next destination for covering in the series of webinars is quite simple. Currently, it is the world's fifth largest economy, and India is set to become the third largest by 2030. With immense and growing population and consumer market, India continues to be a priority for foreign investors, financial sponsors, technology leaders, energy majors. Everyone has set heavily on India, and as such, India-related disputes and India as a seat of arbitration are becoming more and more important globally. So without further ado, please let me introduce our speakers. First, Abhilin Chaturvedi, partner at India's leading law firm, Cyril, Amarchand, Mangaldas. He has acted for clients in both ad hoc as well as institutional arbitration under the ICC, LCA, HKIAC, ICSID, SIAC, and UNCITRAL rules. He has represented companies in the banking and finance, construction, energy, infrastructure, mining, technology, and telecom sector before judicial forums in India and institutional and ad hoc arbitral tribunals. Vladimir Talanov, partner at ЕПАМ law offices. He represents clients in international arbitration and litigation and specializes in complex cross-border disputes, as well as advises on international trade law, foreign investment, and issues related to the work of the World Trade Organization and the Eurasian Economic Union. He has extensive experience of representing clients in arbitration proceedings under ICC, LCA, UNCITRAL, and SCC rules, as well as coordinating litigation in the courts of Russia, the USA, EU countries, Turkey, and India as well. For example, dispute with the Indian shareholders of a Russian-Indian joint venture. And last but not least, Робин Гровер, Ms. LL.M candidate. Robin is an India qualified lawyer with over 6 years of professional experience in the field of international dispute resolution. Before enrolling at the MITS, Robin was working as a principal associate in the international arbitration team at Cyril, Amarchand, Mangaldas. He has represented and advised diverse clients from over 10 countries in ad hoc and institutional arbitrations, including under ICC, SIAC, LTA rules, as well as in associated enforcement and annulment proceedings. Now, let us begin with Robin and his presentation on arbitration in India.
Good evening, everyone. It's a pleasure to be here with all of you today to discuss the topic of arbitration in India. Before Abhileen and Vladimir dive into the recent arbitration-related developments in India and the specifics of the India-Russia arbitrations, I would like to set the stage with a brief overview of the arbitration landscape in India. To give this, I will present on 7 topics. Emma, can we have the presentation, please?
Sure, 1 second. Let me... Here we go. Can you see it?
Yes, it's visible now. Yes. So this would be the outline for my presentation. I will start by giving a brief overview of the history of arbitration in India, right up to the enactment of the current law, which is the Arbitration and Conciliation Act of 1996. This historical context will help us understand the evolution of arbitration in India. Following this historical snapshot, I will get into the broad structure of the Arbitration Act of 1996. We will explore its key provision and how it has shaped the arbitration landscape in India as of today. Next, I will discuss the need for the amendment to this 1996 Act, which culminated into reforms in 2015, 2019, and 2021. I will list the key amendments of the 2015, and Abhileen will discuss the reforms taken in 2019 and 2021 subsequent. Now, after discussing this brief overview, I will focus on certain aspects of the Indian arbitration regime, which I believe are particularly relevant as of today, especially from the point of view of the foreign parties. This will include meaning of the arbitration agreement and the law governing it, the seat of the arbitration, and what are the preferred cities where arbitrations are held in India. Then I will discuss about the arbitrability of disputes under the Indian arbitration law. I will then focus on the challenges to the arbitrator and the timelines for it. And last but not the least, the interim measures which can be granted by courts and tribunals in India. Emma, can we start with the next slide?
Sure. Okay.
Let's start with a lesson on the arbitration history in India. So law on arbitration in India was codified when India was under British rule in the form of the Indian Arbitration Act of 1899. However, this was applicable only to certain provinces such as Calcutta, Bombay, and Madras, which are now the cities in India. The scope of arbitration was expanded by enactment of a domestic arbitration act of 1940, which codified the law on domestic arbitration in India. However, foreign arbitration was still governed by two separate legislations, which were Arbitration Protocol and Convention Act of 1937, which dealt with the Geneva Protocol and Convention. And the second was the Foreign Awards Recognition and Enforcement Act of 1961, which dealt with foreign awards under the New York Convention. Now, this 1946 Act, along with the statutes relating to foreign arbitration, governed the Indian arbitration landscape for over 6 decades. However, with the economic liberalization of Indian economy in 1990s, the adoption of the unsettled model law in 1985, and the need to address the lacuna in the procedural deficiencies, India enacted the Arbitration Act of 1996. This new legislation, which is the current regime, consolidated the law on domestic and international arbitration in India. Therefore, to discuss the Indian arbitration regime for today, it is important to have a conceptual understanding of the Arbitration Act of 1996. Emma, can you have the next slide? Yes. So the 1996 Arbitration Act is largely based on the unsettled model law, with certain modification to suit it for the Indian economy. The Act is divided into 4 parts. Part 1 lays out the provision related to the commencement and conduct of any arbitration seated in India. The arbitral award under Part 1 is considered to be an award passed in India and is subject to the challenge and enforcement procedure provided under Part 1 itself. However, there are slight differences in the conduct of the proceedings as well as the challenge and enforcement mechanism in relation to 2 categories. One is domestic arbitration, that is arbitration between 2 Indian parties. The second is an international commercial arbitration. That is one where at least one of the parties is a foreign party. Now, this differentiation is important as it gives to certain differences in the procedure and enforcement mechanism as well. 2 major differences which I would like to highlight, which I think would be important for our future discussions as well, are first, for support for international commercial arbitration seated in India, the parties must approach directly to the high courts in India. The lower courts in India will have no jurisdiction in relation to international commercial arbitration. Now, this is an important factor as the parties can expect more speedy determination of any issues arising in relation to their arbitration proceedings, as the high courts are better equipped in terms of handling such commercial disputes. The second distinction is in the ground for setting aside. There is an additional ground for setting aside of an award in relation to Indian parties, which is on account of patent illegality of the award. This ground is not available in relation to international commercial arbitration seated in India. This brings me to second part, which governs reference to foreign seated arbitration and recognition and enforcement of foreign awards. It contains provisions on reference of the parties to a foreign-seated arbitration by Indian courts and recognition and enforcement under the New York Convention and theoretically also under the Geneva Convention and Protocol. These provisions or the part 2 is completely mandatory and parties cannot derogate from any of the provisions provided thereunder. Now, for an award to be considered as a foreign award, it must meet 3 criteria. First, it has to be in pursuance of an agreement under the New York Convention and theoretically Geneva Protocol or Convention. Second, it must arise from a commercial legal relationship, as India has adopted the commercial reservation under the New York Convention. However, it is important to highlight that Indian acts or Indian legislation does not define what commercial means. But there is a general assumption that investment arbitrations or awards arising from investment arbitration will not be considered to be under the purview of a commercial relationship. Third criteria for a foreign award is that it must originate from a reciprocating territory, as India has also adopted the reciprocity reservation under the New York Convention. Now, these 3 criteria are to be met for an award to be considered as a foreign award, which can be enforced under the Part 2 of the Indian Arbitration Act. Part 3 and Part 4, which are not relevant for our present discussions, relate to conciliation and supplementary provisions. Now, this brings me to the amendment to the Arbitration Act and why amendments are necessary in this landscape. The Arbitration Act, enacted in 1996 with an objective to achieve time and cost efficiency for settlement of commercial disputes, was a significant advancement at that time. However, it struggled to keep up pace with the international procedures and best practices which had evolved from 1990s till 2010s. Moreover, there were conflicting judicial interpretation of certain provisions, the criticism of Indian judiciary in relation to their interventionist approach, and India's ambition to become a preferred destination for arbitration highlighted the need for legislative reforms. In response, substantial amendments were made in 2015, 2019, and 2021. Abhileen will discuss the 2019 and 2021 amendments. So I will only provide a brief overview of the major 2015 amendments, as I believe this is important to highlight how India has become a pro-arbitration destination in the recent years. First, the court now should endeavor to dispose of any application for appointment of arbitrator within 60 days. In practice, this 60 days period has not been strictly followed in India. However, this provision has certainly expedited the process of appointment of arbitrators and naturally the commencement of arbitration proceedings arising from that. Second, the amendment in 2015 introduced a detailed schedule on the challenges for ineligibility of an arbitrator, which were based on the IBA guidelines introduced in 2014 itself. Now, this introduction or integration of the IBA guidelines under the Act has streamlined the process of disclosure as well as the procedure for challenges of the arbitrator in India. Third, the amendment has permitted parties to approach Indian courts directly for interim relief in aid for foreign-seated arbitration as well. Fourth, interim order of the tribunals nowadays are considered to be as order of the court. This has led to automatic enforcement and reduced the time which was required for enforcement of an interim order passed by the tribunals in India. Fifth, which I believe has been one of the most significant achievement of this amendment, is providing a strict timeline for arbitrations to be conducted in India. It provides that an award shall be made within 12 months from the date of reference, and this 12 months can be extended for a period of another 6 months on request of the parties. However, this 2015 amendment, which was applicable in relation to both domestic arbitration between Indian parties and international commercial arbitrations, was subsequently modified in 2019, where this 1-year period was made mandatory only for Indian parties and not for an international commercial arbitration. It was decided that the timeline will be only directly in relation to international commercial arbitration. Another significant achievement was that petition for setting aside of an award have to be disposed of as soon as possible, but maximum within a period of 1 year. This ensured that there is no delay in relation to setting aside procedure and subsequent enforcement as well. And the last but not the least was the amendment removed an automatic stay which were earlier granted if an execution if a setting aside petition was filed in relation to award. Now an award can be enforced even though setting aside petition has been filed unless and until the courts grant a stay on the same. All these factors have made arbitration in India more cost and time effective and true alternative to Indian litigation. Now, this brings me to certain critical aspects which I believe are relevant for foreign parties as well. First, I will be dealing with the meaning of the Arbitration Act and the most hotly debated topic in the recent 5 years in relation to the law governing the Arbitration Act agreement. The Indian Arbitration Act, as I said earlier, is based on unsettled model law. Accordingly, they have adopted option 1 of the arbitration agreement provided under section 7 of the model law. Now, therefore, for an arbitration agreement to be valid in India, it has to be in writing. It could be through electronic means or any other correspondences as well. Further, the requirement of it being signed as provided under the New York Convention is not applicable. Therefore, the form of the arbitration agreement is immaterial if the intention of the parties is clear and the parties will be referred to arbitration if there is an arbitration agreement in place. Now, but what is the law governing the arbitration agreement in India? Under the erstwhile regime, that is the 1940 Act, the Supreme Court of India in certain cases had adopted a contract approach. That is, if the underlying contract, the law governing the underlying contract will also govern the law of the arbitration agreement. This position has changed subsequently, and in the recent years, certain judgments have come which have now said that the law governing the arbitration agreement, unless until it is specified in the agreement, it shall be the seat approach. That is, the law governing the law of the seat will be applicable to the law of the arbitration agreement as well. This brings me to my next slide on the seat of the arbitration agreement. Now, parties are free to decide the seat, otherwise, tribunal will determine the seat of the arbitration. This is important as parties in India, specifically in relation to international commercial arbitration, have generally adopted seats such as Delhi, Bombay, Hyderabad, and Bangalore. This preference is not random, but is driven by several factors. First, most of the Indian corporations have their registered or corporate offices located in all these major cities, making them convenient and more accessible for the parties. Second, the high courts associated with these seats are well regarded for their expertise in commercial disputes and are considered to be better equipped to provide an efficient and effective resolution of any issues which may arise from the arbitration proceedings. Third, most of the prominent Indian arbitral institutions, even though the recent ones or the old ones, are located in major cities like Delhi, Bombay, etc. These include the India International Arbitration Center located in Delhi, Mumbai Center for International Arbitration, International Arbitration Mediation Center, which recently opened up in Hyderabad, and Bangalore International Mediation Arbitration and Conciliation Center. These arbitration institutions, which have come up in recent years as well, are now providing state-of-art facilities for arbitrations to be conducted in India at a very competitive cost, which make them more prevalent and are expected to gain more prominence in the upcoming years. Last but not the least, many of the India's leading law firms are situated in these cities, and the arbitrators also have their offices in these cities as well. This reinforces their appeal as the arbitration hub, especially for the Indian subcontinent. Now, this brings me to my next slide about what kind of disputes are arbitrable in India. Indian courts will not refer a party to arbitration or enforce an award arising in relation to any subject matter which is not capable of settlement through arbitration under Indian law. However, the Indian Act does not list down the categories of non-arbitrable disputes. In general, the commercial dispute between private parties involving only private rights and not affecting any third-party rights will be considered to be arbitrable. Basis this, Supreme Court in 2011, in a celebrated case of Booz Allen, listed down certain categories of disputes which are considered to be non-arbitrable in India. This list was subsequently modified by the Supreme Court in several judgments, which culminated into a 2020 judgment called Vidyadrolya, which laid down a four-fold test to determine arbitrability of disputes in India. It held that a dispute will not be arbitrable when A, it relates to action in rem or actions that do not pertain to subordinate rights in rem. Second, A, it affects third-party rights or have erga omnes effect. Third, it relates to sovereign and public interest function. And fourth, if it is expressly non-arbitrable as per statutory provisions. Now, basis this and the culmination of the Indian judgments, I've listed down certain categories of dispute which are non-arbitrable in India. First is criminal disputes. Second, matrimonial disputes. Third, guardianship matters. Fourth, insolvency and winding up matters. Fifth, testamentary matters. Sixth, trust-related matters. Seventh, eviction or tenancy matters. And there are two kind of disputes which are generally considered to be in the gray area. One is allegation relating to fraud. Now, fraud-related disputes were earlier considered to be non-arbitrable. However, Supreme Court in recent judgments has clarified that only fraud-related disputes where there are serious allegation of fraud will be considered to be non-arbitrable. Now, what is this serious allegation of fraud? The serious allegation of fraud arises when A, the arbitration agreement ceases to exist due to its being vitiated by fraud, and B, when allegations are made against the state or state instruments relating to fraudulent or malafide conduct, giving rise to public interest law matter rather than concerns of private contractual relationship. Thus, cases of corruption, bribery will generally be excluded from the list of arbitration. Another gray area was in relation to disputes relating to intellectual property rights. While Indian subcontinental countries like Hong Kong, Singapore has started arbitration of disputes related to IPR, India has not provided such enactment. In India, dispute relating to intellectual property rights will be arbitrable only if it relates to subordinate contractual rights. Therefore, for example, in a case of royalty payments, a dispute in relation between the two parties in relation to royalty payments will be arbitrable only in relation to those parties. The court cannot determine whether the patent from which the dispute is arising was valid or not. Now, this brings me to my second last certain aspect, which is the challenge to the arbitrator. There are two circumstances which are also under the model law. One is in relation to justifiable doubts about independence or impartiality, and the second is lack of agreed qualification. As I earlier mentioned, the Arbitration Act has incorporated the IBA guidelines on conflict of interest. Now, this incorporation has been done through two schedules. One is the fifth schedule and the second is the seventh schedule. Fifth schedule provides the circumstances which give rise to justifiable doubts about the independence or impartiality of the arbitrator. The other is the seventh schedule, which renders an arbitrator ineligible, and this can only be discounted by a waiver from both the parties. This brings me to the last topic, which is about the interim measures. Yeah. So under the Act, parties to an arbitration agreement can seek interim measures both from arbitral tribunal as well as from the court. In 2015, substantial amendments were made in relation to the interim measures, and now the key notable factors of the interim measure provisions in India can be discussed. First, the kind of interim measures which can be granted by either the tribunal or the court are vast in general, ranging from preservation of assets to securing the amount in dispute. The party may approach a court for interim measure before or during the arbitral proceedings, or even after that till the time of enforcement of the award. However, if the arbitral tribunal has been constituted, the court will only interfere if the tribunal's order is non-efficacious. That is, if the tribunal cannot provide an adequate remedy in relation to interim measures. This brings me to how tribunal can also grant similar interim measures as can be granted by the court. However, these interim measures will only be granted during the proceedings, that is, from the commencement till the award is passed. And these interim orders of the tribunal are now deemed to be an order of the court. Like all these critical amendments which have been introduced and the structure of the Arbitration Act shows that how India has emerged as an active player in the field of international arbitration, offering a robust legal framework and infrastructure in relation to arbitration proceedings. Given these developments, and I'm sure the other developments which will be discussed by Abhileen and Vladimir, India could serve as an attractive alternative destination for Russian parties and other international stakeholders seeking a reliable and effective venue for arbitration. With that, I would like to conclude my presentation.
Thank you, Robin. And before we turn to Abhilin's presentation, let me ask you a few questions. So the question I would like to ask is about the issue of diversity of languages and cultures in India. So as we know, it consists of many states which speak different languages. So how does that affect or impact arbitration in any way?
Yeah. So diversity in Indian languages would not be an issue for foreign parties arbitrating in India. As I mentioned earlier, for court support for international commercial arbitration seated in India, the parties must approach a high court high court of competent jurisdiction. So proceedings before Indian high courts are in English. Further, most of the lawyers who are practicing before these high courts and arbitrators are fully conversant with English language. Therefore, the diversity in Indian languages will not be a problem for arbitration in India. Abhileen can probably supplement on that.
You've answered the question perfectly, Robin. The language adopted in Indian courts is English. So maybe if you go to lower courts, which are district courts, there may be some influence of the local language, but in at least international arbitrations, it's largely in front of High Courts and Supreme Court, which is in English language.
Thank you. So I don't think I see any questions in Q&A or chat, so I suggest we turn to the next presentation. Please let me know if it would be comfortable for me to turn the slides or if you would like to do it yourself.
I'm okay either ways.
Okay, I'll continue swiping them.
Yeah. So good evening, everyone. I'm Abhileen Chaturvedi. I practice at a law firm in India. My focus area is arbitration, and I advise on both ad hoc and institutional arbitration. Through my presentation, what I'll seek to cover are the two amendments of 2019 and 2021. Can we go to the next slide, please, Emma? Through my presentation, I'll cover what the amendments under the law were through 2019 amendment and 2021 amendment. Of course, I'll not go into each and every detail of those amendments, but I'll touch upon the important amendments at least. I'll thereafter touch upon the regime of enforcement of foreign awards in India. Post discussing the enforcement of foreign awards in India, I will touch upon some recent judicial developments, the concept of sovereign immunity, and thereafter developments around the law of arbitration in India in the past 1 year or so. And lastly, why India could be a significant seat of arbitration, not just for uh, Russian parties, but foreign parties in general. Can we move to the next slide, please? The next one, Emma. So, as Robin just discussed, the 2015 amendment, post the 2015 amendment, there was another larger set of amendments to the Arbitration Act in India through 2019 amendment. Under this particular amendment, uh, one of the more controversial things, if I can call it as that, was the introduction of an Arbitration Council of India. Through the Arbitration Council of India, what the legislature proposed was that there will be a council. That particular council will accredit arbitrators and arbitral institutions. And after accreditation of these arbitral institutions and these arbitrators, of course, cases will be then administered by the respective institution or the arbitrator. Now, the issue with this particular council, which became a point of controversy, was that this body was largely composed by government officials, and not just not even a divide between the provincial and the state and the central government. Largely, all the members were appointed by the central government. Therefore, it was seen as a lot of government engagement in an arbitration process. This is yet to come into full effect, even though this was proposed in 2019. So you can imagine the sort of pushback that it has received from all the stakeholders, which is why it has not been perhaps introduced till date. The 2019 amendment also introduced the concept of confidentiality. Yes, after the introduction of 1996, we took several years in introducing confidentiality as a subject in arbitration proceedings. We thereafter also introduced a fourth schedule, which was already there through the 2015 amendment. But under the 2019 amendment, and there is a correction in that slide, the 2019 amendment, when it came to Section 11, has been notified. And what it does is that it provides a band of fees for the arbitrators, which the High Court may consider. The earlier version read that it should award arbitrations on the basis of those schedule of fees. In this particular amendment, the legislature gave the High Court the power to consider that schedule of fees. The amendment also introduced time limit for filing of statement of claims and defense. Uh, it it is something to appreciate that arbitration proceedings can also take a fair share of time in India, which is why through the 2015 amendment, there were timelines proposed. Under the 2019 amendment, there were further timelines proposed and followed thereafter on what should be the timelines for completion of pleadings, which is your statement of claim and statement of defense. Can we move to the next slide, please, Emma? Under the 2019 amendment, a concept was also introduced on uh, qualifications and experience of arbitrator through an age schedule. Now, why I have mentioned this, even though in the subsequent amendment, this was omitted, is for the reason that it was omitted with a caveat. So this particular 2019 amendment introduced these qualification criteria for arbitrators, which was thereafter omitted, but I'll come to that when we reach 2021 amendments. 2019 amendment also introduced the time limit for the arbitral awards. It basically imposed a timeline that statement of claim and the pleadings have to be completed within 6 months. 12 months post completion of pleadings, the arbitration proceedings must end. This period of 18 months is extendable with consent of both the parties for a period of 6 months further. And beyond that, if there are further delays, then an application needs to be filed at the court of the seat of arbitration to seek further extensions. In India, we are a litigious country. There are litigation issues on very minor things as well. And one amongst the issues was the applicability of the previous amendment. So in 2015, when the amendments were proposed, it became a confusion on the arbitrations to which those amendments will be applicable to. Through the 2019 amendment, the legislature clarified that unless the parties agree, the 2015 amendment will only be applicable for arbitration proceedings commenced after 2015. Can we move further? Yeah. Moving on to the 2021 amendment. There is a slight bit of background to these particular this set of amendment. This was introduced through an ordinance on 4th of November 2020. Why that particular date is of significance is that on the same date, there were proceedings going on before the Supreme Court concerning a very talked about treaty arbitration against the government of India under the Devas and Antrix issue. On that particular date, the Supreme Court asks whether there is a scope of settlement. There is an argument made on behalf of the government that there are certain corruption issues on the award of contract itself, which led to the arbitration, which led to the particular dispute, and therefore there is no scope of settlement. On the very same day, this particular ordinance comes into effect, which is which later formally amends the act as well. Under this particular amendment, as you will see, it was specifically stated that any award where there's a prima facie case of fraud or corruption, if that is made out in the application for setting aside, that award will be unconditionally stayed. So through the 2015 amendment, there was an amendment brought out that there will only be a conditional stay of arbitration proceedings, which this particular amendment sort of they did not take it away, but it revised to a large extent. The other amendment that it introduced was that under Section 43J, it vested the powers with the Arbitral Council of India to decide upon the qualifications of the arbitrators. So under the 2019 amendment, there was a schedule introduced which laid out the qualifications of the arbitrators. It was subsequently omitted by the 2021 amendment, which then provided that the Arbitration Council of India has the power to decide upon the qualifications of the arbitrators. Now, these are some of the pivotal amendments which were made to the Arbitration Act of India, and which has in fact steered the arbitrations in the right direction. And these amendments were introduced to make India the hub of arbitration, at least within the South Asian context. And it has, in fact, complemented the growth of arbitration jurisprudence in India, as well as streamlining the arbitration processes in India. Can we move to the next slide, please? One important aspect that I particularly wanted to touch upon, and given the fact that we are sitting in an audience which may perhaps have questions on what would be the regime of enforcement of foreign awards in India. I particularly chose this topic. What are foreign awards? So foreign awards are defined under the Indian Act, and these are awards on a commercial dispute, which may be enforceable in India, subject to the fact that these are rendered in proceedings seated in any of the New York Convention country, and which has been notified as a reciprocating territory by the central government. Robin briefly touched upon this issue in his presentation, and I'll not delve into this further. But if can we move to the next slide, please? Yeah. So it's a dual process under the Indian Act. It has to first be a New York Convention country, and it has to be notified so by the Government of India through its gazette. An application needs to be made under Part 2 of the Indian Arbitration Act before the relevant High Court, wherever the award debtor's assets may be situated. Uh, Under the 2015 through the 2015 amendment, there was an amendment laid out which allowed a foreign award holder to proceed with enforcement through the High Court directly, which means that they don't need to go to the district court, and the proceedings can be filed directly before the High Court. It saves a lot of time, that particular amendment. So once you apply to the High Court for enforcement of the award, and if the criteria which is set out under Section 47, 48 is met with the particular arbitral award, then that award is capable of being enforced as though it were a decree of an Indian court. Emma, can we move to the next slide? Yeah. So now, what are the requirements what are the things which must accompany a Section 47 application? It should be accompanied by the original arbitration agreement or a duly certified copy thereof. Um, Evidence to prove that the award is a foreign award. Uh, if, of course, if the foreign award is in a foreign language, then it has to be a certified true copy of the translation needs to be adduced as well. And subject to the code being satisfied that all the criteria are met out, this will thereafter be enforced in India. Next slide, please, Emma. Yes. So if those three conditions are met with, an award will be enforced in India. However, Section 48 lays down the criteria in situations, sorry, the situations in which a foreign award may not be enforced in India. So which are largely identical to the convention, to the New York Convention provisions. And these provisions may generally be identical to a lot of other countries' laws when it comes to setting aside of arbitral awards. Just to enumerate all these conditions, first is where the parties were under some incapacity to the arbitration agreement, which is to say that they were not capable of entering into the arbitration agreement in itself. Uh, Second is where the award debtor was not given notice of the arbitration proceedings, which effectively ties in well with the argument that um, fairness to the process was not maintained. Then arbitration decisions have gone beyond the purview of the mandate of the arbitrator. The composition of the tribunal was not in accordance with the agreement between the parties, or the award is yet to become binding on the parties. Next slide, Emma. The other two grounds are where the subject matter of the award was not capable of being arbitration of being arbitrated upon in India. So to explain with an example, In the UK, betting is legal, and there are lots of these apps and websites which allow betting. Now, if there are certain arbitration disputes arising out of those particular contracts, those will not be enforceable in India. Enforcement of the award will also be refused if it contravenes the public policy in India. Now, what is this public policy? We'll deal with it in the slides further. Limitation period for enforcement of foreign award is now has now been the controversy has been laid to rest through the Supreme Court's judgment in Government of India versus Vedanta, where it clarified that the residuary provision under Article 137 of the Limitation Act will be applicable for enforcement of foreign awards, which is a period of 3 years from the day when the arbitral award becomes enforceable. So you have 3 years to apply for enforcement of a foreign award in India. This is different from the limitation period which is applicable to a foreign decree or foreign judgment, which through another judgment was clarified that that particular limitation will be governed by the laws of the country where the judgment was rendered. Moving further, Emma. Now, in this particular judgment, one of the opposition to enforcement was taken as if the award is allowed to be enforced, it may contravene the provisions of Foreign Exchange and Management Act in India. Now, the court in this particular case, in the other case which I have cited, Vijay Karya versus Prismian, has, and in two other judgments prior to this, has clarified that violations of FEMA will not be taken as a ground to refuse enforcement of foreign award. The argument, the justification of the court is twofold. As Madras High Court had explained, that FEMA is an enabling statute. Therefore, it is not a statute which contravenes, but it allows parties to seek permissions. And therefore, given the nature of the statute itself, you can go to the authorities, ask for leave, and then maybe they may permit the enforcement of that particular award or whatever needs to be done as part of that award. The second limb of the justification that the courts gave was that the award is only being brought to India for enforcement. The award has been rendered in a seat, in a foreign seat, and it is only being brought to India because the assets of the award debtor is situated in India. Therefore, there has to be a minimal look at the arbitration award, and it should not apply the same criteria. The court should not apply the same criteria as it would apply to setting aside of an award to while enforcing the foreign award. So basically, the scope of inquiry is very limited when it comes to enforcement of a foreign award in India. Moving further. So as I just touched upon some time back that what is the meaning of public policy? The court attempted to clarify this situation in a much earlier judgment, and where it said that it will be taken as contravention of public policy if the making of the award was induced or affected by fraud or corruption, if it is in contravention with the fundamental policy of Indian law, or if it contravenes the basic notions of morality and justice. So, if the award is somewhat hit by either of these three circumstances, it will be taken as an award in conflict with public policy in India, and therefore that particular award will not be enforced in India. We can move to the next slide, Emma, after this.
Did I swipe correctly?
Yes, you can move to the next one after this. Yes.
Okay, thank you.
Yeah. Over the past year and continuing this year as well, there have been certain significant certain significant judgments when it comes to law of arbitration in India. One of the most important judgments considering uh, company law in India was this particular judgment of Cox and Kings versus SAP India Private Limited. The court upheld the doctrine of group of companies, which basically meant that non-signatories to arbitration agreement could also be made parties to the arbitration proceedings. Of course, the parties would have to show that the non-signatory was an active participant in the decision making of the contract. The non-signatory was involved in the negotiations and performance of the contract, or the non-signatory somehow is in a position to to a large extent is in charge of the day-to-day functioning of the signatory. And in those situations, non-signatory could be made parties to arbitration proceedings in India, largely seen in the cases of joint venture entities or subsidiary entities where it's not the subsidiary, but it's the holding company which takes all the which does all the decision making. And only because it's the subsidiary which is party to the arbitration agreement, that does not mean that the holding company cannot be made party to the arbitration proceedings. So this judgment clarifies that position, and to a large extent, we'll see how this judgment will impact the arbitration proceedings, where holding companies or non-signatories could be made party to arbitration agreements, to arbitration proceedings in India. Moving on to the next one, Emma. This was another judgment which remained a major bone of contention for a very long time. And in fact, the judgment which finally was rendered is the third judgment of the Supreme Court in the case at hand. What had happened over here was that in an arbitration in an agreement where there was an arbitration agreement, uh, parties went to a court of law, went to a commercial court. Before the commercial court, the opposite party made an application that the parties must be referred to arbitration. Court took notice of the arbitration agreement, referred the parties to arbitration. Against that particular order, a challenge was made before the High Court, where the challenging party made an argument that the stamp duty under the contract which contained the arbitration agreement, that was not proper, and therefore the contract itself is inadmissible in evidence. Because the contract is inadmissible in evidence, the arbitration agreement which is contained within that particular contract is also incapable of being performed. This particular judgment was taken to the Supreme Court. Supreme Court initially gave a view that this doesn't seem to be correct, and parties must go to the arbitral tribunal, and the arbitral tribunal must be uh, left with this determinant question. That particular judgment of the Supreme Court was referred to a larger bench. The larger bench then said that yes, until and unless the stamp duty is paid, the agreement itself does not become enforceable under the law, and therefore the agreement itself is invalid. If the agreement is invalid, then of course the arbitration agreement is invalid as well. All these controversial judgments were then put to rest by the final judgment, which said that even if an arbitration agreement is contained in an unstamped agreement, that particular arbitration agreement has to be enforced. And on the basis of the principle of competence, this particular question must be left for the arbitral tribunal to decide on whether the stamping of the particular document was proper or not. Moving further, Emma. This is a this is a Delhi High Court judgment, and while it's not something, it's not a huge judicial literature, but the reason why I had put this in was that third party litigation funding is something which has always been, I mean, there is nothing in the legislation in India which distinctly allows it, but there is nothing under the law which distinctly prohibits as well. This particular judgment gave credence to third party litigation funding in India. Over here, what had happened was that after receiving an arbitral award, it was sought to be enforced against a third party funder. The court clarified that you can't have enforcement proceedings against a funder, and it clarified the difference between Indian law and the UK law, because under the UK law, it gave the court the authority to decide the entity for who was responsible for paying the fees. Because an identical clause or identical practice was not prevalent in India, therefore, the third party litigation fund could not be made to pay the arbitral award. Moving further. Now, while all the other judgments which I just spoken of are they sort of complement the arbitration process, and they speak volumes of how court gives a lot of backing to the law of arbitration in India, and attempts to maintain independence and party autonomy before the arbitration proceedings. This particular judgment became a major uh, point of controversy because this is a judgment which was rendered after many round of litigation proceedings. So just to give you a little more background, an arbitral award was rendered. It was challenged before a single judge of the Delhi High Court. The single judge of the Delhi High Court upheld the arbitral award. It was challenged before the division bench. Division bench set aside annulled the arbitral award. Against the decision of the division bench, parties went to the Supreme Court. Supreme Court initially uh, upheld the single judge's verdict and upheld the arbitral award. There was a review petition filed. That review petition was dismissed by the Supreme Court. After dismissal of the review petition, under the Indian jurisprudence, there is this concept of curative petition, which can be filed to avoid any miscarriage of justice. And that particular point of jurisprudence, which is very peculiar to Indian law, was invoked under this particular judgment, under this particular case. And Supreme Court finally, at perhaps the sixth level of proceedings, finally set aside the arbitral award, as the Supreme Court said that it would enforcement of the arbitral award would result in a miscarriage of justice. Just to briefly highlight on what the issue was, uh, a vital piece of evidence was not appreciated by the arbitral tribunal. The single judge had held that this lies in the domain of the arbitral tribunal as to what is the weightage to be given to a particular piece of evidence. Supreme Court finally held that ignoring that vital piece of evidence will change the entire interpretation of the contract itself, and therefore the arbitral tribunal uh, the arbitral tribunal misinterpretation of that particular contract would lead to a miscarriage of justice if the Supreme Court were not to annul the arbitral award. Moving further. Again, this is a topic which I particularly wanted to discuss was because of the simple reason that we are living in a more and more globalized world, and there are chances where awards can be sought to be enforced against state-owned entities. So, to because we are running short of time, to briefly touch upon this, if a state-owned entity is a party to an arbitration agreement, can we move to the next slide, please, Emma? Under these two judgments of the courts in India, Delhi High Court and the Supreme Court, respectively. Both the courts have clarified that if a state-owned entity or if a state subject itself to the rules of the market where they engage in trade, commerce, and business, then in those situations, sovereign immunity is something which cannot be invoked. And if a state-owned entity or a state is a party to an arbitration agreement, after the proceedings are invoked, they cannot take aid of sovereign immunity and then seek not to go ahead with the arbitration, because arbitration by its very nature is commercial in nature, and therefore the courts in India have held that if sovereign immunity is allowed to be exercised at that particular stage post invocation of arbitration agreements, it will lead to collapse of the entire arbitration regime itself. Moving further. Yeah. So So over the last 1 year or so, there have been further committees constituted under the law of arbitration in India, basically to propose further amendments to the act if possible. The thing is that while this particular committee report has been publicized and it is out there for everyone to see, this has not been signed by the government officials, and it has only been signed by the practicing lawyers who are part of this particular committee. So while suggestions have been made by this particular committee, time will only tell if these particular recommendations are actually implemented through amendments under the law. Moving further, Emma. Robin has already touched upon this. There are institutional arbitrations in India. There are, in fact, proliferations of institutional arbitrations in India. There are more and more institutions which have come up. MCIA, which is one of the older institutions in India, has seen a record growth in its case numbers, and which just goes to show that there is a lot of preference being given to institutional arbitrations in India, and people are actively looking at institutional arbitrations as a very valid and a very plausible alternative to ad hoc arbitrations in India. Moving further, Emma. Yeah. Now, for any foreign party or for Russian party in general, India is one of the larger hubs of arbitration, especially in South Asia. Litigation proceedings aside, at least an arbitration proceeding is completed quite expeditiously in India. You can safely say that within 2 to 3 years, an arbitration proceedings can be concluded, which is comparable to any other competitive arbitral seat. India recognizes third-party litigation funding. There is very minimal intervention when it comes to enforcement of foreign awards. There is a strict approach adopted towards corruption and fraud, which will automatically result in either set aside of the arbitral award or non-enforcement of faulty awards. And foreign awards can be enforced in India, even if enforcement of that foreign award may perhaps contravene a local law. With that, I'll end this. If there's any questions, happy to address them.
Thank you, Abhileen. I think we have a few questions from the participants that are directed to you and Vladimir. So I think it's better to cover them after Vladimir's presentation.
Sure.
So, Vladimir, can you tell me if you would like me to swipe the slides or if you would prefer doing it yourself?
I would appreciate your assistance if possible, though to be frank, there is not much to do, not much to click, given that I have only 2 slides. And effectively, those were for me to share with you my experience of, I think, the biggest Russia-India arbitration case we had so far. Actually, we worked with Amarchand on that case as well. Indeed, the leading Indian law firm, helping us with that. And I must confess, it was before all the amendments. It all started in 2011-12. So effectively, many of the new recent developments that have been addressed by the previous speakers were not yet there, and we were willing to expand 2015 amendments to our case, but didn't manage to do that. But it was a huge dispute that lasted for over 10 years, an arbitration case. We always hear that arbitration is so effective and quick. It was an international arbitration, though at first the three arbitrators there were the former Indian Supreme Court judges. In that sense, the quality of expertise was indeed very high, but I think we managed to dive in the full-fledged, India style of arbitration, and this way we managed to reveal a number of interesting differences that are, in a way, not thought of by the Russian parties. Many of those are effectively with respect to the differences in legal background and the legal culture that we have. India has a very long-standing legal tradition, a very strong legal profession. I would say in that sense that Russia is just catching up. And generally, I think the differences in our mindset were also very visible. So some of the things which seem to be novel and unclear to the Russian mind would be absolutely straightforward, understandable, would not trigger any concern from the Indian standpoint, and vice versa. So I think my idea is just to share this experience, tell you about some of the interesting facts, differences, difficulties that the Russian parties faced, and then just give you the overall perception that we had as a result of this arbitration. Though, as said, and I do really appreciate this big work that is now being undertaken by the Indian legislator in order to improve the system and make India a really attractive seat for the arbitrations, not only involving the Indian sides, but also for international parties to enter India and select India as their seat. So if you would be so kind to switch to the next slide.
Just a second, I think my...
Take your time, no rush. So just some of the specifics that attracted my attention and that really made this arbitration case different as compared to other arbitrations, mainly Western arbitrations that the Russians are used to, are there on these two slides that I sort of assembled. So to begin with, the very big difference and the very big issue that was impressive for us that related to the arbitration agreement. And I think my colleagues emphasized that the arbitration agreement needs not to be signed separately, but generally that is more typical maybe for India, for Singapore, for the UK, for the US traditions. In our case, the arbitration agreement was effectively signed. We dealt with a case where we represented a state authority responsible for foreign investments, and who was deemed to have signed the arbitration agreement for this state agency. Effectively, a person that we know in Russia as a trade representative. And we know that guy has, from the Russian standpoint, has absolutely no capacity to sign arbitration agreements, to enter into any binding contracts for state agencies. And we operate on a very strict authority system where the authority needs to be sort of approved, stamped, demonstrated, and unless a person had indeed an authority to represent a legal entity or a state in our case, then it is very unlikely that a continental tribunal continental-minded tribunal, European continental-minded tribunal, would accept this arbitration agreement as valid and binding on the parties. And that it was the mindset actually of most of the lawyers that worked with that case before we jumped in, because we did not arrive to that arbitration at the most early stages, as would be otherwise desirable. And then it turned out that the concept of implied representation, circumstances of the arbitration agreement being made, do really matter in the Indian state practice and in Indian arbitrations. So for the members of the tribunal, it was evident that a person named as a trade representative of the Russian Federation coming to a meeting should not bear a separate power of attorney, should not necessarily be authorized separately by the decree of the government to represent the government. Though for the Russian mindset, it is straightforward and evident. So that was one of the grounds of challenging the jurisdiction and challenging the arbitration clause, but effectively it was all in vain, because the approach towards these implied powers is much broader in the perception of the Indian arbitrator, the Indian judge, than in Russia. Secondly, the big issue that turned out to be a really big mess for the Russian mindset was the issue with the powers of attorneys and the representation of the clients. You know how we work in Russia, and it is so simple, straightforward, and obvious that we never thought it could be otherwise. When a Russian law firm is hired by any client, what we usually get from the client is the power of attorney. And then we are used to engaging foreign counsel that may also get a power of attorney from us, from the client, depending on the needs of the local regulation of the profession. And then we all act as lawyers, representatives, and that is it. However, in India, it worked differently. I now see that similar approaches are there in Malta and in Singapore. So for the Indian lawyers, they effectively are lawyers in the process. And that means that they would not be able to sign affidavits in your name, in the name of the client. So they act as lawyers. They need to have the client sign the affidavits, sign the papers with respect to the facts. And that implied a lot of our involvement, because we were no longer lawyers ourselves, but to the contrary, we were the representatives of the client. So we acted as clients in the proceedings, and the lawyers effectively not even needing the powers of attorneys. And yes, we understand that for arbitration, those are not formal things, but then we had to sign affidavits. Whereas in the Russian tradition, we are so used that lawyers can always sign all the papers, and you don't need this additional time of someone specific. So your lawyers usually sign all the documents. So when it would come to legal pleadings, when it would come to legal statements, lawyers can do that on behalf of the client. Whereas whenever we have any factual aspects in the pleadings, it always had to be signed by the client. Either by the client themselves or by ourselves. Obviously, it was easier for the client, for us to go to India. And then we would come to the second issue. And yes, I understand that arbitral proceedings are not necessarily as formal, not as formalized as state court proceedings, but in that case, to avoid any chances of the other party to challenge it, and there, as far as we did not have any other findings of the tribunal to the contrary, the position was to make sure that all the affidavits would be sworn and all the affidavits would comply with the local rules. And for that, we had to have those affidavits apostilled and sent to the tribunal, and that worked fine. But whenever we had an issue with Indian state courts that would issue those or other measures in support of arbitration, and we had those experience in various parts of India, in West Bengalia, in Calcutta, in Orissa, in Delhi. So when it would come to state courts in support of arbitration, those powers of attorneys and sworn affidavits turned out to be a real issue. because as it turns out, I would be speaking for Calcutta, a very peculiar region with a very different approach towards many of the procedural aspects, I say, compared to Delhi. But in Calcutta, the issue was that the courts were very reluctant to take the court, and the company law board effectively were reluctant to accept the powers of attorneys that were issued in Russia, notarized in Russia, apostilled, and sent to India. And it took us 1.5 years to get a decision that I think actually created a precedent, and that was published in some of the local digest of precedents, and was cited by a number of further Supreme Court decisions, where the courts of Calcutta finally were sort of bound to accept apostilled powers of attorneys when it comes to foreign parties. So the court of Calcutta at first requested that the Russian client comes to India and swears the power of attorney and the affidavit before the local notary in India. What is the outcome of that? What is the message of this thing? India is indeed extremely diverse and very different. It's a huge country with so many different approaches towards the procedure in different parts of India. And even the sworn affidavit that was sworn in Delhi was once not accepted in Calcutta because of the difference in the wording that the notaries use. And that has to be taken into account. Delhi, in that sense, and I guess Mumbai, are more in a way advanced, or maybe the wrong word, more Western, used to the Western style, more used to foreign parties involved in the proceedings, and therefore maybe easier in that sense. Whereas some of the more distant parts of India, should you be involved in the proceedings in those parts of India, may be very tricky, and even lawyers from Delhi would not always be able to help you with the local rules and the local specifics in Calcutta. That is different in the Russian mindset, because all the procedural rules in Russia are federal. So we have all the standard, uniform, identical rules, which do not differ. Therefore, it makes no difference if you go to Moscow, St. Petersburg, Sochi, or Vladivostok, you get to have the same procedure. What is not that in India makes India very unique, and what requires some involvement of local council to make sure that you comply with all those formalities, not to have any postponements for solely procedural reasons. And then the difficulty that we had actually was with this legalization with the apostille in Moscow, because the Indian embassy in Moscow, no in St. Petersburg, do have this service of legalization. Therefore, it was an issue. And now, you know, the difficulties, because notaries in Russia do not work in English. So we had to find a notary that would accept a document which would be bilingual in 2 columns, and then sign it here, and this affidavit would then work. And well, sometimes it was easier to do it in Delhi. So I think we traveled, well, I myself traveled more than maybe 10, 15 times to India just to sign the documents and have them duly executed. But as said, maybe it was excessive caution in arbitration. It would not be necessarily there for arbitration purposes, but that is something that needs to be done for state courts to make sure your position is bulletproof. Then one more interesting thing with respect to the domestic courts in support of arbitration related to this joint venture, and we had a seat in Delhi, and therefore we all had a perception, we all expected that, at least we in the Russian mindset, had a feeling that if a domestic court in India would be approached in support of arbitration, that would be a court in Delhi. But it turned out that in the course of the life of this joint venture that started several years before the arbitration, there was already one court in India approached with respect to the matters of this joint venture. And therefore, the competent court in relation to all aspects happened not to be the Delhi court, but the Calcutta court. That was the court of the the first approached court with respect to the dispute between the parties. So in that sense, we had to send all the matters in support of arbitration to that very court. And as said, that added additional logistics, that added additional aspects of differences, counsel. So I mean to say that in order to determine the competent court, a lot of factors need to be taken into account, and therefore, for some of the parties, as were our opponents, it was a very wise move to move first to the Court of Calcutta to make this court competent, because they felt more comfortable in that Court of Calcutta than, say, in the Court of Delhi. And with respect to the proceedings and the styles of the proceedings, as said, it was all before the amendments that restricted the time frame for the arbitration with 1 year. And in that sense, the arbitrators did not feel under any pressure. But generally, what interested me was not even the overall length of the proceedings, but more the pace and the manner in which the proceedings were held. Most of the Western arbitrations, in sense of hearings, would operate on a standard mode of, say, 2, maximum 3 weeks of hearings. And I think in this case, given that there was no foreign arbitrator on the panel, and we had former Supreme Court judges as our members of the panel, members of the tribunal, they were more inclined towards the court-style hearings. And as we joined the process later, there was no chance for us to change that. So effectively, we had hearings every month or two of, say, 2 days, and then that dragged out for a couple of years. But then we had to reconstitute the tribunal for various reasons. And our move was to bring in a foreign arbitrator. So the 2 Indian Supreme Court judges and 1 foreign arbitrator. And that effectively changed a lot in the way of behavior, because on the one hand, there could have been some pressure from a foreigner, a person coming, not only for the parties, but even for the arbitrators. So with respect to the parties, I think they were relaxed that we have to fly to India every month or every second month. But when it was with respect to an arbitrator, it all started moving faster, more hearings in one and the same set. And therefore, I think it was a very wise move. If you have, that is my perception, if I were to get to an arbitration with the Indian, say, arbitrator, Indian chairperson, then I think for a foreign party, it makes a lot of sense to have some balance with a third arbitrator being from outside India, best from some common law jurisdiction, that would, on the one hand, speak the same language with the arbitrators, but on the other hand, potentially put more of the Western style discipline on the tribunal, and make it work in a way faster. Because generally, the perception that I had is that unlike in our mindset, for instance, arbitrators, counsels, they indeed enjoy discussions of various aspects of Indian law. They feel they are developing the Indian law. And for us, there was a number of cases when we wanted to go further, go straight to the merits, not discuss the law, let's discuss the facts and finish it. But we saw that both for the parties, for the counsels and for the arbitrators, it was a matter of vital importance to generally understand how the law develops, and they feel they are here in this room developing the law. So maybe we are more oriented on in result, want to rush to the end, and therefore the clients sometimes expect decisions to be faster. Whereas generally, I think that is a matter of the tradition and profession in India. general respect to the profession, respect to the law as a discipline, respect to the law as a regulator of social relations. So it takes some more time, and that should be taken into account by the Russian parties, not to push aggressively on the tribunal and the local council, but give this additional space to develop the legal concepts and to have sufficient time for those discussions. So then with respect to arbitration, interestingly, I know that for some of the modern arbitration centers, there was a lot done so that to digitalize the proceedings, whereas in the arbitration that we were in, still for the arbitrators, for the administrators, and for the council, it was a pretty paper-heavy stuff. Parties bringing in books full of bags full of papers. And I think it is on my next slide. Emma, thank you for clicking. When one of the arbitrators passed away and we had to reappoint the new arbitrator, it was a big fuss that it is compulsory for the new arbitrator to take hold of the papers, physical papers of the arbitrator that passed away, with all the notes, with all the handwritten lines. Our lady from Singapore was very reluctant to do that. She didn't want to take the papers, but the other two members of the tribunal insisted that she gets hold of it as replacing the arbitrator. So this attention to paper documents was something quite unusual for the Russian mindset, because in Russia now everything is online, everything is filed online, everything is done online. Maybe things are developing, and I guess things are developing, but as said, that was interesting. So we quite often had a lot of papers brought with us as well, with our own notes. With respect to the selection of counsel, I think I mentioned that a lot depends on the arbitrators or the judges, and the brilliant top-notch counsel from Delhi, very well known and highly respected, and very indeed impressive in court, turned out to be not that sort of heard in Calcutta. And to the contrary, the Calcutta guys would not always be that attentively listened to in Delhi. That is, again, something we are not used to, but that is totally normal, given that these local communities in each of the state of India are very strong. And therefore, in each part of India you go to, I think it makes a lot of sense to have a local counsel, to approach the court or the tribunal, to know those people you communicate with. And it does not mean that there is some form of bias or there is some form of something going wrong, but generally it's a matter of perception, it's a matter of communication, it's a matter of listening attentively to what you are saying. And I think it will take a lot of additional effort to break through the wall that may be not necessary if you could find someone local who knows the arbitrator or who knows the judge in the local court. With respect to the formalities, I think I addressed that. With respect to the replacement of an arbitrator, I think I addressed that. We had several issues, well, a number of issues, and many remain unresolved, that the advances paid to the arbitrators effectively never got returned, but I think it is more with respect to a particular arbitrator and not with respect to any peculiarities of general arbitration in India. So once arbitrator stepped down, he just stopped any communications with us, and that is it. But interestingly, one important thing that really significantly impacted our case was this story that is stamp duty. And again, there is a lot of differences in different parts of India, in Calcutta and in Delhi. But the law is that any award needs to be printed on stamp paper, and this stamp duty has to be paid by the parties in advance, one the arbitrators, are ready to render the award, they notify the party of the amount of the state duty that needs to be paid. And interestingly, from state to state, it differs, as said. In Calcutta, it was nothing. 2,000 rupees, 5,000 rupees, no issue. But in Delhi, where we had the seat of arbitration, and according to those rules, the stamp duty was determined, I think, or maybe it is in Calcutta, I don't remember specifically which of the local rules applied, but the stamp duty in our case was 1.5% of the duty awarded. And that was a lot. That was a lot as compared to, and that was again one of the big disadvantages of having your seat in this place or the other. And I think that is also important why a local council should not only arrive to a stage when the dispute is already there, but when the contract is discussed. When the arbitration clause, the seat is selected, it is so important that a local council is there to advise on these minor aspects. And we had to pay this stamp duty, what was a pretty penny, because otherwise the risk was, on the one hand, that the award would not become binding on the parties and you would not be able to enforce it under the New York Convention on the one hand, and on the other hand, there is a risk of confiscation of this award. The state may get it if you do not pay the award. So it's like a state duty that needs to be paid. And as said, from one part of India to the other, it differs greatly. So there was no other way for us but to pay. And that is also something we did not anticipate. So depending on the state, that needs to be checked. And I think that the seat here would be decisive as to the amount of the state duty. So, but generally, I think the bottom line is that India is very diverse. India is very interesting, and indeed, it's not only a continental tradition there, but it's also a very strong local tradition that has developed over dozens of years. And in that sense, a local council should be there with you on board from day one when the clause is drafted, and then whenever the arbitration starts. It is a big mistake, I think, for foreign parties to believe that they can handle it on themselves, because of a lot of local peculiarities and regional peculiarities as well. Then, as said, a good option to bring more Western style discipline to a tribunal would be to appoint one of the members of the tribunal as a foreign member. So it would perfectly balance the local peculiarities with this aggressive Western style. And then number 3 is that still to make sure you do not get challenges against any of the decisions by the opponents. I think it makes a lot of sense to discuss all these formalities, to understand how to proceed best, to comply with it, to establish the logistics, and this way you would be safer if you understand the scheme from day one. So these are my perceptions of the interesting aspects that we faced in India. Should there be any questions or any other requests for comments, I'm at your disposal. Thank you.
Great, thank you, Vladimir. In fact, we do have a few questions, which I think are better to be addressed by you and Abhileen, which of course relates to sanctions. Hot topic for a few years. So the first question is, are there any problems with conducting arbitration in India now due to sanctions against the Russian Federation? Have any of you faced any situation related to that?
So I don't think that there is any issue in conducting an arbitration against a Russian entity in India. But if the question is that how will courts perceive sanctions in India, and hypothetically speaking, if there is an arbitration where a Russian party could not defend itself properly because of sanctions, and that award is brought to India for enforcement or recognition, maybe Indian courts will give weightage to the fact that the Russian party was not capable of representing its case fairly because of sanctions, and therefore that particular award may not be recognized in India. But I'm talking a lot on hypothetics, but it is largely inferable, given the jurisprudence in India, that if a party was not able to represent itself properly, chances are that the result of those particular proceedings may not be recognized in India.
Fully agree with Abhileen. And just one more thing, talking of the sanctions impact on arbitration, I guess the most traditional impact that we all think of would relate to payments and transactions. When it comes to the payment of the fees, payment of any other kinds of arbitration-related costs. I think so far it has been developed pretty well, and I do not recall any issue. We have one arbitration now in the pipeline in India that has been sort of started, and we never had any issue with any payments so far stopped anywhere. But clearly, ultimately, the goal is to find way to avoid big foreign banks and currencies like euros or US dollars. But so far, I'm not sure, at least I'm not aware of the system, how payments would be done in rupees or in rubles straightforwardly. So we managed to pay in US dollars. It was all fine, and the payments were not stopped. But I think to make it absolutely stable, these system of payments need to be developed. They may be already there, but I'm not aware of those yet.
Just to add to that, I believe there is a system already in place where Russian parties can pay to SBI or some other branches in Russia in rubles, which will be converted and paid to the Indian parties in INR in India. So there are systems already in place, I believe, since 2022, when we also had a matter dealing with the Russian party, and the Russian party had to make payments to us.
Brilliant, brilliant. Good to know.
Thank you, all of you. And one last question related to the matter of payments, actually. So one of our participants asks, tell us about the peculiarities of interaction between India and Russia in the current situation of growing trade deals. Is it proportionately reflected in the number of disputes? And what jurisdictions do counterparties to India-Russia deals choose for dispute resolution, and why?
I can hazard an answer to that question. Russia is one of the largest investors in India. There is, of course, not just involvement of Russian parties in infrastructure projects, but there's a lot of natural resources also that come to the country from Russia, and they lead to a lot of disputes. And I wouldn't say that the number of disputes have reduced or have increased. It's perhaps the same steady number, and with the growth in economy, those disputes have increased, but nothing to say that there is a sudden spike in the disputes concerning Russian parties, at least within the Indian jurisprudence that I can say. But yes, there is a lot more queries on the contract, on contract. So just to give you an example, we had a client who had a project in Russia, but they were engaged by an Italian entity. The Italian entity could not perform the contract because of sanctions. And therefore, the Indian party who was contracted by the Italian party could not perform its obligations. So there were queries on how to perhaps address this situation, but it didn't go to an arbitration. Ultimately, parties found a solution and they went ahead with the contract, but not necessarily this situation led to an arbitration because of sanctions.
Thank you. Thank you so much for answering.
I would also say that effectively, indeed, for new contracts that have been concluded over the couple years since, say, 2022, clearly the parties are now moving from the former top selected destinations of arbitration by the Russian parties, LCIA, ICC, arbitration in Europe, SCC, that are clearly no longer now the priority selected places. We have proposed to our counterparties in disputes with non-Indian parties, India as a place of arbitration, a couple of times, but I think that none of these proposals have been accepted so far. What has been selected was Dubai, Hong Kong. And with respect to the Indian parties, I think there was also discussion that we recently had. And again, for the Russian parties, maybe India is still not that widely known or as a place for arbitration. Therefore, the more branded centers like, say, Diak in Dubai, that are now more represented in Russia and more widely marketed in Russia, are still attracting more attention. So these are the names that are known to the Russian businesses, and they are sort of easier agreeing to Diak as a center. But otherwise, I mean, there are not that many options that the Russian parties now have in mind. I said Diak, Hong Kong. Singapore is considered an unfriendly jurisdiction despite those very minor sanctions that have been imposed. And therefore, the next line of options considered by the Russian parties would be India, Turkey, and I think, well, some propose Egypt, Cairo Center, some propose Malaysia. But I think, well, India would be among the first in the second row, but mainly because it is just historically less known to the Russian parties. And that's the only reason why we may not yet have that many clauses with arbitration in India, seated in India. But let's see what happens in a couple of years, because the contracts were just concluded and it takes time before we arrive to disputes. And I would not be at all surprised to see a significant increase in disputes seated in India in the coming years.
Thank you. I think it's a perfect conclusion of our webinar. Let's hope that sometime we'll have to make a new one to update people on the state of affairs and on arbitration in India. And thank you all for participating and presenting today.
Thank you.
Thank you so much.